Hello, everybody. Welcome back to the Conduct Detrimental podcast. This is your co-host, Dan Worley. We have a real special treat here today. We're kind of testing something out. We're going to do an end-of-the-year sort of mini-series and touch on a number of issues, big topic issues going on in the sports law world, and do kind of an overview of the last year as well as kind of preview looking forward where we're going to be in 2017. And the first topic today we're going to touch on is the NCAA and amateurism issues. We've got a great guest in, but before we get to him, I'm going to throw it over to my co-host, Dan Wallach. Dan, how's it going?
Oh, it's going great, Dan. I hope you had a terrific Christmas holiday, and the same to our guest who I'm about to introduce. This, for me personally, is one of the most special of our podcasts. For number one, this is the first time we've actually had a real lawyer on the podcast to match wits with us, and I think we're going to be outmatched. Previously, we've had writers and journalists, but now the time has come. The business of college sports is becoming bigger and bigger, and the tension between amateurism and fairness and equity in the treatment of the athletes, it's colliding. And very few people in our country are better served to address these, tensions than our next guest, Warren Zola, one of the very first people that I met in the sports law realm. I'm 54 years old. I haven't been doing this for that long, and it was only two and a half years ago I even appeared at my first conference, and the second person that I met in sports law after Michael McCann was our next guest, Warren. Warren has been extremely helpful, and I think to enter the space and have the first three people you meet being McCann, Warren, and Gabe Feldman, I don't think you could do any better. That's a Mount Rushmore of sports law thought leadership, in my opinion. Well, Warren wears many hats. He's a law professor. He's the executive director of the Boston College Chief Executives Club at the Carroll School of Management, and he is one of the leading voices on the issues affecting big-time college sports. Amateurism. You'll find few people in the country who have all of these issues, within their area of expertise. O'Bannon, Alston, Jenkins. I mean, I saw him appear a couple of years ago at the MIT Sloan Sports Analytics Conference. He moderated a panel on amateurs or industry, NCAA reform. So without further ado, this is the longest introduction I've given anybody. Welcome to our podcast, Professor Warren Zola.
Well, Dan, thank you. And that introduction is a kinder gift than I've received from many this holiday season. So I appreciate it. Unnecessary and undeserved, but it's a thrill to be here. Obviously, the sports law world is very aware of both of you and your writings and your opinions, and more so this Conduct Detrimental podcast. So I'm thrilled to be one of the first guests you've had. And shout out to Mike and Gabe as well, because they've been fantastic friends and colleagues in this field. So looking forward to this podcast, both today and listening to more in the future. And certainly, as you know, college athletics has become a little bit more under the microscope of late, and there's a bunch of reasons for that. And I hope to look under the hood a little bit today and talk about how we got there and where we're going. Yeah,
and on that note, and Dan Wallach touched on this too, but there's really this tension out there right now, and I think it's each year, each few months, really, it comes more and more into the spotlight, and that's the tension between amateurism and commercialism, and that's really the main topic we're going to really hit on today. Warren, you want to start us off by just giving us kind of a background, a context to this tension?
Yeah, and I think what's really important is to recognize that here we are sitting in the last week of 2016, knowing that the future has brought us to this point, and there's going to be a lot of change in 2017 and in the near future. And I think that college athletics, as we know it today, will look very different in the next year, multiple years, and decade. But look, in the 21st century, college athletics has evolved from quaint contests between colleges into a burgeoning business unto itself. As interest exploded, so too have the media broadcast rights fees, which has created a multi-billion-dollar a year industry. Not surprisingly, with greater revenue available, the stakes have skyrocketed for all the constituents, including institutions, students, conferences, and the governing body itself, the NCAA. The bottom line is that intercollegiate athletics is no longer viewed solely as merely an instrument that provides educational opportunities for students, but has transformed into an essential revenue stream for higher education. The obvious consequence is that many institutions experience tension between their mission to educate and the commercial opportunities that are available to them with regard to college athletics. To combat this new paradigm, the NCAA has crafted rules to govern, and as the bureaucracy has grown, it's further engulfed college athletics. And the end result, as all of us who are lawyers know, has been inevitable. There have been frequent disputes arising from this friction between academics and increasing commercialism, triggering an abundance of legal challenges. And that's what we hope to get into today. There's the issues about compensation, there's issues about employee rights, there's issues about transfers, and there's the general concept of the revenue and what to do with it when you don't have to pay the labor that produces the demand. So that's sort of the big picture context that I think is important to understand, is the growth of the revenue has led us to these cases where finally people are standing up for the students and saying, okay, this is a business, we now need to address the labor that generates the demand as such.
Yeah, Warren, why do you think it's starting to happen with the O'Bannon case and over the past decade? The revenues associated with big time college sports have exploded. Going back 15, 20 years. With some of the TV contracts. Why now? What was the event? Was it just plaintiff's lawyer crafted a theory and that kind of kicked things off? Was there some catalyst that caused the explosion of litigation?
I think, and I may be biased because I've gotten to know him, but I think Taylor Branch's article in The Atlantic in 2011 really played an instrumental role. And when you layer that on with Sonny Vaccaro's vision and the O'Bannon lawsuit, I sort of call that a tipping point, right? In 2011, Taylor Branch, who is a Pulitzer Prize-winning historian, author, wrote a lead article in a magazine that has nothing to do with sports typically, but is well respected in the world. And he talked about this concept of perhaps it's time to pay college athletes, perhaps they're being exploited, and he went into all sorts of detail. And I think for the first time, the world, outside of those of us who are knee-deep in college athletics, said, hey, maybe there's some issues going on here, maybe some of the students need to pay attention to this, and maybe advocates should play a role. I mean, my mother, for the first time, calls me up and said, hey, Warren, what's going on about college athletes? Why are they being, taken advantage of? Now, I had already been to Congress talking about this, but it took this article by Taylor Branch to get my mom engaged to talk about, hey, there's something going on. So I think that might have been a catalyst in part.
Yeah, it's funny. I prepared for this podcast by reviewing some of the leading articles, and the article that caught my attention was the Atlantic article by Taylor Branch. I never knew about it previously, and that was the very last piece that I read minutes before we went on to the podcast. So that I'm going to reread that and see what I can divine from it, because he has some very interesting theories and different models about how to pay college athletes.
Yeah, and I think that article triggered other mainstream articles that appeared, right? Joe Nocera from the New York Times has written a litany of powerful, insightful articles that I would encourage people to read and follow. Sean Gregory, Time Magazine, wrote an article on the cover of Time Magazine with Johnny Manziel, Johnny Football, talking about maybe we should be compensating college athletes. And so I think the fact that it left Sports Law Blog and the White Bronco and all sorts of other specific sports law venues and turned itself into mainstream. 60 Minutes does a piece. All of a sudden it finds its way into the Colbert Report. And all of a sudden John Oliver does stuff at the Daily Show. So all of a sudden the masses are talking about it, and it finds its way into South Park. So all of those things I think played a role. And look, there's a lot of nitty gritty that gets into here, right? There's the 1984 case that set the tone with the NCAA and Board of Regents and antitrust issues regarding whether or not the NCAA could restrict how many times individual schools could appear on television. And for the first time, the Supreme Court decides, hey, wait, restrictions seem to be in a position in a violation of antitrust, rule of reason, et cetera. And so now you can't restrict how many times schools could appear on televisions. And that creates a cycle where schools want to compete. They want to be on television. Now you've got television contracts, more money. ESPN comes around, cable television. They've got a vacuum where they're trying to fill on Saturdays and Fridays and Thursdays and Mondays and Tuesdays and every day of the week. And so now you have this preponderance of slots that are available for college sports to appear on TV. You've got schools that are now competing for those dollars. That starts as conference realignment. Started here at Boston College when Miami left from the Big East to go to the ACC. BC followed suit because you got to follow the money to some extent. And now you've got conference realignment. And so culmination of NCAA Board of Regents finding its way to removing restrictions that were placed on television appearances, conference realignment, schools going after television money, and all of a sudden, Sonny Vaccaro, who once had been one of the biggest proponents for making money off athletes, realizes, you know what, there seems to be some issues, and working with a bunch of lawyers, they're looking for a plaintiff, and that leads us to Ed O'Bannon, who files a lawsuit against the NCAA having to do with names, images, and likeness for EA Sports. And all of a sudden, people begin to realize, hey, this is real money, and maybe the NCAA rules are a little bit overly broad. And I'm happy to talk a little bit about the O'Bannon case because I think that has been the other sort of trigger that has opened up the lawsuits where I think people have said, instead of complaining about it or instead of writing an article in Huffington Post or wherever, people have gone to court. And students have felt comfortable doing that. And that's where the floodgates on litigation have started. And that's where we find ourselves now here in December of 2016.
Yeah, I think it makes sense to start with O'Bannon, as you mentioned, not only because it's where it started, but also O'Bannon, we finally got resolution this year after, I don't know, 3 or 4 years of litigation when the U.S. Supreme Court denied to hear the case. So can you just kind of talk us back from the beginning? What were they seeking? What happened in the district court? Then what happened in the appellate court?
And O'Bannon stands on the shoulders of Jeremy Bloom. So Jeremy Bloom, for real quick history, sued the NCAA in 2004. He was a USA Olympic skier. And he was also recruited as an All-American to play for the University of Colorado football team. And as an amateur skier, you don't make a whole lot of money. As an Olympic skier, you need endorsements to continue to supply you with the revenue needed to train. And he was doing that. And he was also recruited to play football as a kick returner at University of Colorado. While at Colorado, the NCAA told him he couldn't receive any money for training. He couldn't get endorsement money. And his freshman year, he said, okay. And after his freshman year, where he was an All-American kick returner for University of Colorado, he sued the NCAA saying, look, these are two separate sports, football and skiing. The way people get compensated in skiing, I need endorsements. It's long settled that you can be a professional in one sport and an amateur in another. So Ricky Williams at the University of Texas can be an amateur football player for the football team, but he can be a professional baseball player in the minor leagues, which he was. And the NCAA ultimately said, no, if you're going to be an amateur football player, you cannot receive endorsements because we can't attribute that just to skiing. It could be for anything. It could be your modeling career. No, you may not receive endorsements. And so Jeremy Bloom loses that case. Fast forward 10 years to 2014, where Ed O'Bannon, who was an All-American basketball player at the University of UCLA, led his team to a national championship, went on to be drafted in the NBA, played overseas, came back, and is now a dealer at a Las Vegas auto shop selling cars. And he's playing EA Sports with his nephew. And ultimately, his nephew turns to him and says, well, wait a minute, that's you, because he could play a historical team. And Ed O'Bannon said, yeah, it's, number 31, left-handed, bald, 6'6", could go left, et cetera, et cetera. And out of the mouth of babes, he says, well, how much do you get paid for this? And he said, oh, I did it. I'm an amateur. And his nephew looks up at him and says, well, you were when you were in college, but you're not today. How come you're not getting paid? And he doesn't have an answer. And he says, well, maybe I should be paid. right? Even if you accept the fact that the NCAA has amateurism rules that restrict an athlete's ability to seek an endorsement while they're in school, when you're done, why does that money not come your way? EA Sports is making money. The NCAA is making money. UCLA is making money. Why is Ed O'Bannon not? And that really was the genesis of the lawsuit that Ed O'Bannon filed, seeking compensation for names, images, and likeness, NILs, you'll hear it referred to, and saying the NCAA doesn't have the ability to restrict this. It's illegal to do so. Even if I don't get the money while I'm in school, put the money aside. When I'm done. I'm no longer an amateur. Pay me. And the NCAA hung their hat on you're an amateur because we say you're an amateur. Under our definition, you're an amateur. The NCAA, in a small paragraph in the 1984 Supreme Court case, NCAA versus Board of Regents, which we talked about briefly, gives the NCAA some ability to protect this concept of amateurism. They hung their entire hat on, you can't sue us for amateurism, we're immune. And that was the lawsuit.
Well,
which began where we are today. Dan?
Yeah, Warren, I can understand why the NCAA, would be opposed to have athletes being paid directly. But here, this is a situation where third parties are, paying the athletes for name, image, and likeness, and it happens with Olympic athletes all the time. Was the NCAA worried about how allowing this to happen how it could be interpreted in other situations? That once you open the door to this, forget it, it's all gone? Or were they just standing on principle? What was the motivation or the real energy behind the NCAA's strident opposition to this concept that wouldn't cost them a dime?
Well, that's a sophisticated question, and you've laid it out nicely. And I don't want to be snide, and I don't mean to come down on the NCAA, because there's some fantastic people at the NCAA who are very intelligent and mean well. In fact, I think most do. But your question really boils down to, are they worried about a slippery slope, or are they just planting a flag and saying this is amateurism, period? And I think that the answer to that question is yes. I think that it's both. Right? I think that their first line of defense is there shall be no compensation to college athletes that we deem inappropriate, and we're going to make that definition, and we're going to set the scale and the line, and it's okay to get $500 worth of gifts at a football bowl game, but it's not okay to get cream cheese on a bagel or for someone to take someone out to lunch. Now, that has changed over time, right? It used to be that you couldn't give a car ride from one side of campus to the other in the rain for someone who was in your class if they happen to be a student athlete, because that would be an extra benefit, and now you can. But I also think there's this concern of, wait a minute, let's be very clear. We have revenue-producing sports, and then there's everybody else. And I think there's some concern that what does this mean if we start providing compensation, however we define it, to men's basketball, football, and maybe a couple of other individual sports at some individual schools that generate revenue, right? Lacrosse at some schools, baseball at some schools, men's ice hockey here at Boston College. What do we do? And then we've got this other sort of fuzzy concept that I think gets misinterpreted quite a bit of Title IX, and what does that mean for women's sports as well. But I think that there was real concern from the NCAA, but they hid behind the very first defense, which is we define amateurism. The Supreme Court, we think, gives us the right to define what that means, and that's our defense. Now, what's nice about the district court's ruling in California, in the O'Bannon case, was they very clearly, or she, Judge Claudia, I'm sorry, Wilkins, thank you, said, no, this is an antitrust violation. The NCAA is not immune to antitrust claims, and we are going to find that capping compensation to some extent is illegal. We will let you go after full cost of attendance, and we're going to provide money up to $5,000. Beyond that, if schools would like to. Now, the appellate court in September of 2015 struck that down, allowing full cost of attendance, although that became moot because in January of 2015, the Power Five schools were given autonomy and they voted to allow cost of attendance as opposed to capping it at room and board and books, basically, compensation. But they struck down this sort of extra arbitrary amount of $5,000. And the Supreme Court in October of 2016 refused to hear the case. So again, sorry, I teach class and it's a long-winded answer to your question, but the NCAA continues to fight compensation on a variety of fronts, and I think that they've got some rationale to doing so, and I think they've been consistent in extra compensation is bad unless we say it is. And that's what gets frustrating for many of us because it's a sliding scale and it's based on the whims of a few people. And because of the inability for athletes to collectively bargain because they haven't been granted employee status, there's no ability to have back and forth. And the last bit before I yield the mic is, to some extent, what the plaintiffs in the O'Bannon lawsuit wanted wasn't necessarily a court ruling.
Fees.
And fees. The attorney certainly wanted the fees. But what they really wanted was the NCAA or conference leaders to come to the table and talk about this business enterprise that is college athletics with labor and talk about where we're going and what's the best outcome. Look, if some of these cases succeed, specifically the Jenkins case, where any cap on scholarship is deemed to be a violation of antitrust law, and you can have open markets for athletes, I think college athletics as we know it is over. And I don't think anybody really wants that, but the NCAA has been unwilling to negotiate or make changes, and so that's forcing litigation, and I'm not sure anybody likes the potential end result of litigation as opposed to some form of collective bargaining.
I mean, the outcome of O'Bannon, I mean, some cast this as a victory for the NCAA because of the elimination of the $5,000, trust amount. But I see this as a victory, for plaintiffs' lawyers going forward. You have a federal court adjudication that the NCAA's, limits on paying on athlete compensation violate antitrust laws. What are the likely outcomes going forward from this O'Bannon finding? Will there be other O'Bannon cases filed in other federal district courts, or will it be the catalyst for victory in Kessler or potentially in the Alston case? What does O'Bannon mean for other litigation?
Well, I think that's a great question, and I was fortunate enough to spend a couple of moments this fall with Mike McCann as he interviewed Ed O'Bannon and posed those questions to Ed up at his UNH Law School symposium. And I think, sort of big picture, there's going to be all sorts of cases that come forward based on the outcome and the legal determination in the O'Bannon case. But I think O'Bannon very much serves, just like the Taylor Branch article talking about amateurism, is a catalyst. I think it forced conversations that weren't happening before to occur at the college level, at the conference level, at the NCAA level, at sports lawyers conferences, at antitrust conferences. And as a result of that, you see all of these cases coming up. You're going to see sort of individual issues. Look, Ed O'Bannon is going to be a pioneer in sports law, regardless of what happened to his case, because of the conversation and what has come forward. And there are many people like him that, for example, Curt Flood. Right? Curt Flood's specific case wasn't successful, but Curt Flood is known as a sports law pioneer for the changes that he made to free agency and to baseball, and was honored by Congress in the Curt Flood Act in 1988.
All right, so who's on our all sports law pioneer team? Pick five. We got O'Bannon, Oscar Robertson, maybe.
I think Oscar Robertson is certainly one of those people. I think that, entirely selfishly, there are others that I would put in that grouping. If you go to the Sports Law Blog's website or the tweet where they send stuff out on Twitter, there are a whole bunch of pictures of the people who I figure are those pioneers, right? You could certainly put Maurice Claret in there because he founded stuff. You could certainly put McNally and Messersmith in baseball, John Mackey, Ed O'Bannon, Reggie White, Curt Flood, Marvin Miller. Now, I know you asked me for 5. I guess I'd put Flood and Miller in there, maybe Oscar Robertson. But again, there's a lot of people in there, and we'll probably get off topic a little bit. But I think Ed O'Bannon should be in there because he is changing the conversation on the business of college athletics. And again, that conversation is out of the really small, focused individuals, academics perhaps, and now it's broader.
That's a great point. I think, to me, the O'Bannon case was kind of anticlimactic because, as you mentioned, the changes that were made actually took place before the end of the case. But I think the long-lasting, you're going to see it cited in every case moving forward. This is the case that got Jeffrey Kessler thinking, hey, maybe there's another antitrust challenge out there. And maybe we're not sure, but maybe the Kessler case, which is the Jenkins case we're about to get to in a minute, maybe that's the one that ultimately takes down the NCAA model or forces the NCAA to come to the table and change the way they're doing it. And so I guess we should just get right into that. There's 2 other cases, the Alston Jenkins cases. They're consolidated in the Northern District of California in front of the same judge as the O'Bannon case. Can you give us an update on what those cases are arguing and where they stand?
Yes, absolutely. And so, as recap, the O'Bannon case had to do with names, images, and likenesses. And this is the ability for a college athlete to be compensated, not even by the school, but to protect their names, images, and likenesses and to have a proprietary right for that. And that was that case. Alston, and now it's merged into Jenkins, is broader and far scarier, in my opinion, to the NCAA because if successful, it would shake the foundation of college athletics as we know it today. And ultimately, what Jeffrey Kessler, who's the lawyer for Jenkins and now Alston, is arguing is that ultimately scholarship caps, meaning the restriction by the NCAA that allows schools to compensate an athlete to a full scholarship or even a full cost of attendance, is an antitrust violation of the Sherman Act and therefore should be deemed to be illegal.
Can you explain for our audience the difference between a scholarship or a grant and aid and what you refer to and what a lot of people in the industry refer to as the full cost of attendance? What is the distinction between the two concepts, and how significant is that distinction?
It is significant, and basically a grant and aid or a full scholarship is what the NCAA up until January of 2015 was allowed to offer, quote, full scholarship athletes. And what that meant was the school would pick up room and board and a couple of other expenses such as the cost of textbooks for a college athlete. And that is a sizable amount of money, and I don't want to diminish that. I was a really bad Division III athlete. I didn't get a full scholarship, and a full scholarship would have been tremendously helpful. However, even though there's a full cost of attendance by federal law is different than the cost of attendance, which is how much the federal government and the school have decided it costs to attend that particular school. And so going beyond tuition, room, and board is full books, travel, other expenses and fees that the school will impose upon a student. And that is set for any student. So if you happen to be an English major and a school says, we're going to give you a full scholarship, we're going to cover your full cost of attendance, an English major at any university would get X. And if you were a football player at the same institution, they couldn't give you X. They would give you slightly less than X because that's what the NCAA said they could give. Now, again, in January 2015, the Power 5 conferences voted, and they decided to allow schools the ability to give that gap to meet full cost of attendance. to put it in context, the average variance between a full scholarship and cost of attendance across the country is around $3,500 a year. And so basically, up until January 2015, a scholarship student at an institution would actually get more if they weren't playing a sport and they were getting their full cost of attendance. And that's sort of what that argument was about, was whether or not schools could provide that full cost of attendance. Most schools didn't want to do it. Why? Because it's more expensive, period.
So the Alston case addresses the gap between the scholarship amounts and what you characterize, or what everyone characterizes as a full cost of attendance. So so that's the Alston case, and that's not the Kessler case.
No, the Kessler-Jenkins case says even a full cost of attendance violates antitrust law. You cannot restrict compensation, period, without there being collective bargaining and the labor exemption to protect you. So let's talk about football versus college football. In the NFL, there is a salary cap. That is allowed. Why is that allowed? Because labor law supersedes antitrust law and says, look, if both sides, meaning the players, i.e. the union, and the league, i.e. the owners, collectively bargained and agree upon a whole bunch of terms that are formulated into a collective bargaining agreement, and even if there are terms in the CBA that otherwise violate antitrust law, for example, a salary cap or a entry draft, we will let those stand as legal because they've been collectively bargained, and we're going to grant them a labor exemption. So all of those concepts that we know in professional sports would otherwise be illegal but for collective bargaining. At the college level, we have these caps, whether it's cost of attendance or full scholarship. Yet, as we all know now, there has been no collective bargaining. There has never been the ability for the college athletes to come to the table and say, hey, we're okay with you capping our scholarship, but you know what? We want a certain number of days a week off, or we want less games, or we want full medical insurance coverage for any injuries that we incur while we're playing, even if those injuries continue beyond our time. And so that's the challenge in the Kessler/Jenkins case, is this restriction on our compensation violates antitrust law without the protection of the labor exemption.
So the Kessler case is basically looking to blow it all up, right? I mean, this is guessing part on your behalf and on my behalf, but what would it look like if the Jenkins case is ultimately successful?
If they have total victory, which many doubt is possible, but is at least plausible, there is no ability for a school to say, we can't pay you more than X. Now, they can decide that they won't pay more than X, but a school would have the ability, if they wanted to pay more than full cost of attendance. So, for example, for a 6'7" starting left tackle for a college football team, and multiple schools wanted to recruit that player, instead of every single school calling them up and saying, hey, we're going to give you a free ride, come to our school, we're going to pay you $400,000 a year if you play for us. And there's no cap on what they could pay. So it really is open markets. And for those of you who are interested in open markets, I would strongly encourage you to seek out the work of Dan Rasher and Andy Schwartz, who are two sports economists out in the Bay Area who are brilliant. They were experts in the O'Bannon case, and you can find their information online. They are the brightest minds I know in this field. But ultimately, we're talking about free markets. And that's what scares the NCAA, because a lot of schools are going to say, hey, I understand by law we can't restrict it, and as a function of that, we're out of big-time college athletics. It's too expensive. We are now going to go to the Division III model. And that's a possibility in the horizon.
Right. All right, this is going to be a softball, but what do you make of the arguments that by colleges that they're losing money or they're not profitable, or if this happens, we're going to go under, we're not going to have sports anymore. At the same time, we're seeing, coaches getting paid millions and millions of dollars and all these beautiful new facilities being opened. How do you reconcile, how that would work if players started being paid?
Look, it's no doubt that running a college athletic department is wildly expensive, right? Many schools have 20 sports. You have men and women's sports. You have huge rosters. You have tons of demand. It is an expensive proposition. There's no doubt. But and schools, universities are nonprofit institutions. They're granted tax-exempt status. And so it behooves them not to show profit. However, even if a school shows me a bottom line of saying, hey, we broke even or we took a loss, in my opinion, you're talking about priorities and decisions as opposed to we're losing money. Let me give you an example. If a school such as Ohio State has their own airplane and they charter their football team to games, or Clemson football spends $55 million on a football facility, right? Well, you don't have to do that. You could take that money, keep your existing stadium and facility, which is phenomenal, and that money could go towards the athletes and not be shown as a $55 million expense for facilities, but for players. Same thing with coaching salaries. So it's all how schools choose to spend their money. Don't forget, the NCAA signed an 8-year, $8.8 billion contract for March Madness. There is money to be had at the Power 5 schools. The Division I schools who aren't in the Power 5, and there are 1,200 of them, they are not making a lot of money. So when we talk about there being a lot of money in college athletics, I really restrict that to the 65 schools in Division I, and the programs that are making money is really football and men's basketball.
I mean, you pointed out a stat earlier today on Twitter that there are 47 athletic directors who earn in excess of $500,000 a year. And, I dug a little bit deeper. You look at college football coaches and basketball coaches, there are 110 D1 football and or basketball coaches that earn in excess of $1 million, annually. So the money is coming in. They're turning a profit if you look at the economic reality rather than, any accounting methodology. And where is this headed? Ultimately, I see, Jeffrey Kessler trying to, blow up the current system, but will it happen in the courts? Or will the litigation pressure spur some voluntary action to maybe create a payment model, either modeled after Olympic athletes, a salary cap, or some quasi-free market? Yep. What is going to happen first? Will it take another litigation loss for the NCAA for there to be real change, or is there some movement already afoot?
I think the answer to that is both. I think that there is some movement afoot, but I think that the litigation is what exerts that leverage and pressure that forces the NCAA and the conferences and the university presidents to the table to have these conversations, unless we get collective bargaining because of employee status for students. But let me be clear, right? I mean, there's a wide spectrum of recommendations or what people ultimately would love to see. And I might as well, since you haven't asked, I'm still going to give you. Here's what I'd like to see. I think that open market concept scares the heck out of me because I think college athletics as we know it is over. And I think that there is a value for college athletics, right? Those of us in academia and those of us who've gone to college, we love having these opportunities for the students. And there is an opportunity for a student to learn on a football field or in a basketball court or in a field hockey game. They can learn transformative skills that you can't recreate in the classroom, right? Leadership, teamwork, how to win, how to lose, how to deal with adversity, all of those things that you can't do in a classroom. So I think there's value there. But ultimately, I think that there needs to be some form of compensation. So I don't understand why the Ed O'Bannon case, where schools or students should be able to find money outside of the university system to be compensated for endorsements, names, images, and likenesses. There's also an opportunity where if the NCAA really felt strongly about this, pay the student athletes, put the money in a trust fund. If the student graduates, they get some of that money. If they don't graduate, if they leave early, if they drop out of school, then perhaps they don't. But, the concept of, Johnny Football being told you can't sell your autograph to outside vendors. We're not talking about this being state money that came through, through taxes. We're talking about someone wants to pay him $15 to sign an autograph. That's a violation of the NCAA rules and somehow makes him a professional and no longer a student. Yet someone like John Mayer could go to Berklee College of Music, play at Harvard Square, and get paid to write a soundtrack and release a CD, but he can still go to class on Tuesday, and his professor's not looking at him saying, well, you got paid. You're not really, quote, a student here on campus. I just don't understand that because it happens all across the board for anybody unless they happen to play NCAA sports.
Couldn't we tie the payment, or actually the payment would reduce the temptations for these kind of ticky-tack violations, selling your autograph or accepting, de minimis type benefits because you need, living expenses, month to month. Couldn't you tie a payment model, and condition it upon, remaining in good standing and lessen or reduce the incentive for athletes to accept improper benefits from agents or whomever? Don't those two go hand in hand?
There's no doubt. I mean, there's all sorts of rules that are restricting and forcing some of these issues. There's no reason why you couldn't have an advisor/agent while you're in school dealing with some of these things while you're a student. But let's also remember one component here that's not the fault of the NCAA or college athletics is the rules regarding the draft eligibility that the NFL, the NBA, and others have imposed on colleges, right? If you are an elite hockey player or baseball player and you want to go make some money and you don't want to go to college, go for it. You're drafted out of high school. You can go to the minor leagues, the junior hockey league, whatever. But in basketball and football, you don't have that choice. And that's not because the NCAA says you have to play here. It's because the collective bargaining agreement with the NFL and with the NBA says you can't enter this league out of high school. And as such, we're going to treat colleges as the minor leagues. And that will be the training ground. So, for example, if the NBA said, look, we've got a new policy. You can enter the NBA right out of high school. However, if you decide to go to college, that's fine. But you have to spend 2 years before you're eligible. All of a sudden, the college athletes who want to play basketball at the highest level can either enter the league right away, which worked just fine for Kevin Garnett and LeBron James and a whole slew of other people. Or if you go to college, you actually have to spend 2 years because many of us believe that there is value at college, that they'll develop as people as well as players. Same thing with the NFL, right? If there was a minor league for the NFL, even if you accept the argument made in the Claret case that an NFL high school, the high school player is unready to compete in the NFL, well, let there be some sort of minor league or development league where you can play, where you don't have to go to school. You don't have to play these games of eligibility and how, what grades are you getting and all that sort of stuff. If your career is going to be in the NFL, then don't send them to college. And that's not the fault of colleges or even the NCAA. Those are eligibility entry rules that the leagues themselves have crafted.
Yeah, I think it'll be interesting to see how that changes going forward. I would argue that there's at least some options for basketball players because they have the ability to go overseas and play for, we've seen, $1 million contracts for them doing so, Emmanuel Mudiay. And then recently in the NBA collective bargaining agreement, they actually upped the NBDL salaries to, I think, around $75,000, which is, obviously not what they would make in the NBA, but it's at least more of a living wage than it was before. So there's at least some routes, but in football, there's really nothing. I mean, you have to go to college and you have to stay for 3 years, or else. And obviously, the NFL and football players probably have the greatest injury risk, which is another scary aspect of the sport. You look at the Marcus Lattimores, who was, by everyone's estimation, a future NFL star. Has 2 terrible injuries at South Carolina, and now he doesn't have any. I mean, I think he may have gotten an insurance policy, but wasn't able to play in the pros. And that obviously leads to this other debate that's been going on with players skipping bowl games. And we don't want to get too far afield, but I think all of those issues tied together are just fascinating.
No, absolutely, and I think that you those are 2 really important points that you've made. Number one, I wholeheartedly agree with you. The NBA is making strides and providing opportunities outside of the college world. Adam Silver and Michelle Roberts have taken this concept seriously. They have increased the money that is invested in the D-League, which now provides some semblance of opportunity to stay here in the States as opposed to going to Europe, which is still a viable option. They also have agreed to come back to the table and have these conversations about maybe we should readdress this. And so that's still open. But don't forget, these collective bargaining agreements, the future players, meaning those in college, that the future players in a particular league are not members of the union, so they don't have any say in what's going on. And members of the union, meaning current players, never are super keen about younger players coming into the league to take their jobs. But the NBA is doing far better than the NFL. Turning to the Marcus Lattimore point, and you now have current players sitting out of bowl games to protect themselves from health risks. Christian McCaffrey and Leonard Fournette, among others. What I find amazing about this is it took this long for players to recognize their future value. I totally understand the coaches and the fans who say, well, go out there and play with your teammates and win the game. But this is a business. And the schools have taken advantage of this relationship for years and years and years, and people have accepted that. And finally, players are starting to stand up and say, hey, you know what? You made a lot of money off of me. You've sold my jersey with a number at the college bookstore. You've reaped those benefits. And now when I'm thinking about my future in the NFL, I'm going to skip out on a, quote, meaningless bowl game to ensure that I make a couple more dollars in the league. And people are saying, oh, my God, I can't believe that's happening. You're also seeing, again, it's sort of a similar concept, not exactly the same, but you're having issues about transferring, right? Can players transfer without schools restricting their ability? And everyone's up in arms about, well, you have to sit out a year. This isn't fair. All of a sudden, it's free agency. You made promises to the school. Why should this college basketball player be allowed to leave school A for school B? That's just not fair. But no one blinks when a college basketball or football coach leaves after promising their students, I'll be here, to go improve their careers. That's okay. But for a college athlete to do it, people seem to think that that's crazy. And again, big picture, this is a huge business. And I think finally the athletes are beginning to realize their role in it. They've got some leverage, they've got some say, and they need to be selfish to some extent because they don't have a say at the table.
Yeah, I want to turn to the possibility of a court blowing all this up. I think we're seeing a trend in increasing judicial recognition of the NCAA's amateurism rules having some serious antitrust issues, as well as the collision of the amateurism and big business. Several recent court opinions, the Berger case out of the Seventh Circuit, the concurring opinion at least, made some reference to how the outcome could be different if you're dealing with viewing scholarship athletes as employees, from big time athletic programs. Are we heading towards the point that we're going to have a seismic court decision that will change the course of college sports? I'm not so optimistic that will be in the Northern District of California or the Ninth Circuit, where Alston and the Jenkins case are currently cited, because the same judges and the same federal appellate court that placed some kind of limits on the win for O'Bannon, they're going to rule upon the same issues. So where will victory for the athletes and players ultimately come from? Is there a case? If it's not going to be the Kessler/Jenkins case, what future case do you see as potentially changing the face of college sports?
Again, a great question. I think there are, a ton of cases out there that individually are going to damage this concept of amateurism that the NCAA has held dearly since they created it sort of in the mid-1950s, even under Walter Byers, who ruled the NCAA from 1951 to 1987, created restrictions, decided to coin the term student athlete to keep the NCAA in schools safe under employee status and workers' comp rules and all that sort of stuff. So, there's a lot of individual cases. The Kessler/Jenkins case is a huge one. But there are individual cases having to do with employee status. And, is there a single case that we point to and say, this is the one that did it? Or do we say, look, death by 1,000 paper cuts? We had, 20 cases, all of which have moved the needle a little bit. And we are now beginning to have people talking about tax-exempt status. All of a sudden, if college athletics no longer is tax-exempt, does that cause problems? Does Title IX play a role? Does collective bargaining come apart? Because the NCAA says, hey, look, collective bargaining is actually in our best interest as opposed to the students or the players. because we can have antitrust violations that otherwise would be deemed illegal if we collectively bargain and we give up a couple of things like medical coverage or disability and loss of value insurance to elite athletes, so that if a player gets injured in a bowl game, they're really able to cover themselves with insurance as opposed to a cap of a couple $1 million, right? Yeah. And part of that's when you look at the pros, you see how much money is being made on those television deals, right? The NBA, the NFL, Major League Baseball, NHL are all wildly successful with media rights, and they're only blossoming. And it's a big business. And I think that to say this is the single case that's going to blow up college athletics, I'm not sure there is one, but I think that all of these cases together, right? I mean, many of us are in 2016 today saying, boy, I can't believe it hasn't happened. But think about how far we've come in 3 or 4 years, right? The conversations, where those conversations are happening, right? Congress is talking about it. The president, at least President Obama, was talking about it. You know, we're doing podcasts and we're writing articles and there are cases and students are standing up and they're playing the role of activists, sometimes successfully and well thought out at Missouri, sometimes poorly thought out and poorly executed at Minnesota. But finally, students are starting to stand up and say, wait a minute, we've got a voice here. I think that a seminal moment would be if a bunch of teams at the, let's say, Final Four say, we're not playing today because we want our voice to be heard. I think that something like that, a strike, if you will, from college athletes who are willing to stand up, I could see that being a seminal moment, if you will. But I'm not sure there's a particular case other than potentially the Kessler lawsuit that could do it. But I think that when you look at college athletics in 2020 or 2025, I don't think people will even realize how different it was in 2013. That the industry will be so radically different, I think, for the better. Now, maybe not for the average fan, but certainly for the athlete who won't feel as exploited as they may today.
Would treating athletes as would treating big-time college athletes as employees, quote-unquote employees, for purposes of getting overtime pay, would there be any far-reaching consequences of that beyond having to pay them a salary? Would that create other issues for the colleges beyond merely complying with the Fair Labor Standards Act?
Sure. I mean, expenses are going to go up. Schools are going to decide whether they want those expenses to go up, whether that's a priority for them on their scarce resources, right? And there are going to be decisions that are going to be made, and they're either going to be made at the conference level or individual schools are going to say, hey, look, we understand where the law is saying that we are required to go at Division I. We're out. It's just not that important to us as an institution for our mission. And that's what people have got to remember, right? And many of us are out there sort of advocating, and I'll throw myself under the bus as well, for student advocacy in terms of for the athletes, right? The most important thing is trying to find an individual school and how they fulfill their mission and what role athletics should play in that. And the schools that I think are doing a terrible job are the ones that aren't actually educating their students, right? The argument that schools make and the NCAA makes is, hey, look, you're being compensated because you're getting a free education. Well, that argument stands up if education is being provided, but when it's not, when classes aren't being taken, when individual students are being told they can't major in something, when you're missing weeks of school to play classes, I think that's a problem as well. And schools need to decide what's important for their mission and then the role that college athletics should play in it. And again, when you come back to the very intro of our podcast, we talked about how much money is out there. Look, that commercialism, that money is enticing, but schools might say, that's fantastic, but it doesn't help us fulfill our mission. We're out of here. And I think that's a great decision for many schools. Now, fans may not like it, but I think schools need to stand up and decide what's important to them. And I think that's what's been missing to some extent at some schools.
That's an interesting point. I think the biggest thing that scares me, especially about, let's rewind a few minutes when we were talking about what the consequences of the Kessler-Jenkins lawsuit would be. It would be create this free market. And I think the biggest thing for me is, I don't know if we trust schools to be able to control their own spending and therefore, take money away from the academic side to put into athletics, which would be wrong. But we'd have to see. I mean, that's obviously very speculative at this point. I think an important point on that case, and I meant to jump in before but didn't have a minute, is that schools wouldn't be required to pay athletes. They would
Absolutely not.
They would be given the option to do so.
Right. It's the legal right to pay more than you are, but you're not required to do so. But all of a sudden now you're going to have variance among individual schools in what schools want to maximize that compensation, which schools don't. And I think you'll see a huge divide between public and private institutions. You'll see a lot of conferences. I would suspect a conference like the ACC, which has a lot of elite academic private institutions, is less likely to embrace a full compensation model than, let's say, another conference. I'll just pick SEC, where there's a lot of public institutions that spend a lot of money on football and basketball, and that's their choice. But I think that you can see individual conferences making decisions that say, look, this isn't right for us because this isn't how we want to use our scarce resources. And other conferences say, yeah, we're all in. And that's fine. That's the right for schools to do that. But you will see, you've got 65 schools in the Power 5 conferences. I can guarantee you that not all 65 of them wanted to increase spending in sports if this model erodes or improves or changes in the next couple of years the way many of us think it might.
Yeah. Do you see college NCAA college athletic payments going in the direction of an Olympic model or name, image, likeness model? I remember Gabe Feldman wrote a really nice article, submitted a proposal to the Knight Commission that proposed trust fund. Something that we've heard about a lot, that would create a fund under which outside third parties, media companies would provide payment, and the athletes wouldn't be able to touch it until after their graduation, after their eligibility expires, provided that they remain in good standing, et cetera. What's stopping that from immediately taking hold? It seems to address the parity issue among colleges because they're not paying a dime.
No, I think it's a great point. I'm biased. I'm friends and a huge fan of Professor Feldman. I'm also an alum at the sports law program from Tulane Law School, and so I'm biased there as well. But I think Gabe's proposal makes a lot of sense. And look, if schools are crying poverty and saying we can't afford to pay our athletes, okay, well then let Nike pay it, or Under Armour, or Adidas, or Coca-Cola, or Gatorade, right? And that does away with some of the Title IX concerns, right? If a men's basketball player can get paid, a couple $100,000 for someone to wear their sneakers, right? The school doesn't lose money, and the player goes out and gets money, and there's no Title IX issues, and all of a sudden they're being compensated. And so now, as we all know, right, some of those endorsement deals are more than you make in a professional contract playing for a particular sport. And so if Ben Simmons at LSU is making a couple $1 million a year from Nike, well, maybe he'd be back for sophomore year to keep playing for LSU. But since he can't get any of that money, away we go. I've got no problem at all with a trust fund. I think that you certainly could make an argument, go ahead and get paid while you're in school, right? A lot of people talk about, well, how would the college athletes work together on a team if someone was making money and someone wasn't? Well, guess what? That's the real world. And I can guarantee you there's academic departments on campus that are being, salaries are being paid differently, and they all seem to get along reasonably well. So, I'm not sure the money has to be tabled, but if that's the way to get it through, I'm perfectly happy with having the money in a trust fund, and you get it when you graduate.
Yeah, but how would you ameliorate the unfair recruiting advantages that certain big-time schools would enjoy because their media rights and broadcast rights are worth far more than the broadcast rights of a lesser school?
How is that any different than what's going on now, though, right? I mean, they have better coaches or better notoriety, or they're better feeders for the NFL.
Yep.
It's all
That's
similar.
the point.
Right. We could talk about competitive balance, and we could talk about, well, maybe that's not fair and all that sort of stuff, and how a small school may not make as much as a large public university. But guess what? The New York Yankees have more money to spend than, pick a team in Major League Baseball who's a small market team, right? The Kansas City Royals. That's the world, and that's open markets, and we can agree or disagree that that's the right thing, but you let the market decide. And there aren't any of these artificial caps or restrictions that may or may not be illegal in there. Now, again, we may decide we don't like that world. We may not like the end result, but that's a moral argument and not a legal argument, right? That's just free markets, right? I wish school teachers were paid more than basketball players. But you know what? The market has decided how compensation goes, and I'm okay with that.
It's a great point. And I think we wanted to dig into some more details on these cases, but I think we've hit the high points, so we can probably skip over. There's a, Johnny Vassar filed a lawsuit against the NCAA and Northwestern. Yep. We had a case in the Seventh Circuit, the Berger case, which dealt with employee status as well as sort of the Northwestern unionization efforts. But I think if you're interested in those, I think you can go out and read about them. We've hit most of the high points here, and we've kept Warren twice as long as we promised him for. It's kind of our MO here, unfortunately.
When he said 30 minutes, I just had to just laugh because I knew there was no chance we would cover all this ground in 30 minutes. We didn't get to every topic, but it gives us a good reason or excuse to bring Warren back, which, he could cover a lot of different topics, not just NCAA issues, because he's well versed on a number of subjects within the realm of sports law, not just NCAA. I mean, after all, he's the wizard behind the curtain at Sports Law Blog. If you're always wondering who's the guy tweeting at Sports Law Blog, well, 9 times out of 10, it's going to be Warren. Maybe once in a while, it's Mike McCann. So Warren has his finger on the pulse of a lot of different subjects in sports law, and I definitely want to have you back. What do you have? What do you have going on over the next couple of months? Any major projects? What have you been working on?
No, just doing some writing and some thinking, and as many know, many of us are collaborating on a book with Professor McCann. Yep. That's going to come out at some point in 2017, a new book on sports law.
So it's our big book deal.
For some, maybe not for the contributors, but I think it's going to be a fantastic book, and I've written a book on college athletics, not surprisingly. But I think that for the audience out there, college athletics in reform that's coming there is certainly a legal topic, but it's also a business topic. There's antitrust issues, there's names, images, and likenesses, there's employee status, labor law issues, there's transfer, there's NCAA issues. There's a lot going on. So I would encourage everyone to sort of read up and learn about it. But there's a lot of things that are going on out there in the world of sports law. Huge case going on with baseball in the minor leagues. There's all sorts of exciting things that are happening. And I just encourage people to learn more about what's going on. And if this sparks some sort of career out there for someone who wants to get into sports law, go for it. But and I apologize for the length of the podcast. If I had been more articulate and a little bit brighter, I could have summarized things better. But such is life when you're a teacher. You just sort of go on.
Warren, this has been our best show. I mean, what do you talk? We want to bottle this and do it again. You've been great. We've enjoyed listening to you.
That's a sad indictment, contract detrimental. But I know that Professor Feldman's coming on in the future, and that will surpass this. I can guarantee you that.
All right. Well, we can give him harder questions and make things tough for him to preserve your number one status if you'd like.
Well, he's far smarter than I am. Sure he'll be able to accommodate and handle.
And me as well. So I don't think I'll flummox him too much. Warren, will you be at the Sports Lawyers Association annual conference in May? And I've seen you there over the past couple of years. That's an important sports law networking event, and probably for me the best event to attend every year.
Yeah, it's a fantastic place. I love going every year. I've been going since I was a student in 1991 at Tulane Law School. And
have you ever missed one?
No.
Wow.
And the ability to network and meet and learn from people has been just fantastic. And so, it's one of the few ones also where you have the collaboration of both law students and practitioners in attendance. And so I still remember meeting Donald Fear at my very first one as a student, and I cornered him and asked him about how to break into the field. I won't tell you what he said. But I'm still here. But yeah, no, a fantastic conference. There's some good ones around the country, but that's one. If you can make it, it's usually end of April, early May. The Sports Lawyers Association. Get involved for people. It's well worth doing. And again, I know that this is coming out end of December. I hope everyone has a wonderful holidays and a happy and safe New Year. And be careful out there.
Thanks, Warren. Right. That was fantastic. We really appreciate you taking the time, and We mentioned his Twitter account, but it's Warren K. Zola. Be sure to give him a follow. He's one of the best
What does the K
Twitter
stand
follows
for?
out there.
Middle initial is Keith, and my father's name was Irving Kenneth Zola, so we decided that we would both use our Ks as a tribute to each other. So middle initial Keith.
Because I can't imagine that @Warren Zola was taken on Twitter, so you must have made a conscious decision to insert the K when you didn't
Well, I
need
think,
to.
Warren's turning into a pretty popular name now, as my Twitter followers will know. So, maybe I wanted to distinguish myself. But no, it's just I like using my middle initial. It reminds me of my father, who passed away a couple of years ago. So that's what it's there for.
Yeah, and you could also check out Warren's work occasionally when he feels like blogging at Sports Law Blog. Twitter account is @Inside Sports Law. Warren is the executive editor of Sports Law Blog and basically mans the wheel, most of the day on Twitter. So I encourage you to check him out at both accounts. Warren, it was a pleasure to have you. This was a fantastic podcast. I learned a lot just from listening to you. Also preparing helped, but I really enjoyed. Both of us really enjoyed having you on, and I hope you'll come back.
Great, Dan and Dan. Have a wonderful holiday. Enjoyed myself, and for everyone out there, continue to listen to Conduct Detrimental. It's one of the best ones out there, and I think that it's a great opportunity to learn about sports law and find something that interests you. I don't care what your passion is. Find it, follow it, pursue it until you can't learn anymore.
Yeah, if it could happen to a middle-aged commercial litigator, after the age of 50, there's hope for everybody. Anyway, today's episode was called, I guess we can title it System Detrimental. We will return to Conduct Detrimental, next week with Professor Feldman. Warren, have a happy New Year, and I look forward to seeing you soon enough. And Dan, as always, a pleasure, and I look forward to getting back behind the mic with you soon. I think tomorrow we're going to be broadcasting an episode with Paul Anderson, one of the country's leading experts on sports concussion litigation, and then next week Gabe Feldman will be in the studio. And we'll be covering a hodgepodge of different topics with them, from Deflategate to NFL issues. I don't even know where our limits are with Professor Feldman, but I'm looking forward to both those interviews as well.
Absolutely. Busy couple of weeks, because we also have a big overview of everything, I guess you would call it, in 2016. I guess we're doing the top 10 sports law stories. We're bringing in another Tulane Law alum, Ian Gunn, from Sports Esquires, to help us out with that. So
something in the water in New Orleans.
Right. Well, thanks, guys. We really appreciate it, Warren. That was fantastic. Great hearing from you, and happy 2017.
Thank you, and give my best to both Ian and Gabe and Paul. All of them are fantastic guests. You're going to do really well, and your listeners are going to be happy.